Your Lordship,
Stay.
he had told Your Lordship that he won't be there on Thursday, Your Lordship. And
He
Tuesday
will be there.
won't be there, Your Lordship.
Oh.
Tuesday or Wednesday?
Next Friday, in that case, will he be there on Friday?
Yes, Your Lordship, will be there on Friday.
Next Friday, he'll be there?
Yes, Your Lordship.
Accommodation has been sought for on behalf of the learned advocate representing the Coal India Limited. On such prayer, list on next Friday, 15th.
Grateful.
Grateful.
Actually, this is that matter, judicial officer. Probably Mr. Cod is not there, my lord.
Not there today?
Probably I've been told that he is on his legs at court number 12, my lady.
Then it has to be adjourned. When? Next Wednesday, bollen na? Next Wednesday. Accommodation sought for. Next Wednesday.
Not on behalf of the petition.
No, on behalf of the High Court Administration. Learned Senior Counsel representing the High Court Administration. এটা শুনানি করা হয়েছিল একবারও? না মনে হচ্ছে।
Number 8.
My lordship, in this matter, Mr. Moinak Ganguly is appearing. He's on his leg, my lordship. I'm praying for a short passover, my lordship.
No, passover cannot be granted.
My lordship, then I'm praying for an adjournment, my lordship.
देखिए file type minute. Only the order sheet.
So, yes, the other side. Yes. Moinak.
Accommodation has been sought for on behalf of the learned counsel representing the petitioners. Stuff list on 8th June.
Item number 11.
My lordship.
File is not here. The ঝিয়েটা নেই। এটা কি রিট পিটিশন হিয়ারিং আছে? List after the vacation.
Item 12.
Same.
13.
Same order.
14.
14. After vacation. None for the parties.
15.
Same.
16.
Same order.
17.
Yes. To be mentioned. এটা কালকে হলো না না? আচ্ছা, পাস ওভার থাক।
Item number 2.
I am for the petitioner. On previous occasion, the union prayed for Milord correction.
What is the correction?
That Milord, yesterday I failed to appear, Milord.
Oh. In place of the commandant 27th Battalion, something else is to be mentioned.
Milord, he retired under Milord the commandant 27th Battalion.
Yes.
And the others matter, Milord. The commandant is Milord appropriate authority to Milord make representation or maintaining the records. But if any Milord other authority may be directed, we Milord, we will make the representation before that authority. Or Milord may direct the commandant to forward my representation before the competent authority. And the competent authority will comply.
You better call your learned friend. Let her come. I'll put in the proper name.
Great.
Number 4.
4th 11 তারিখ করার আছে।
Number 5.
Yes.
Honorable, I appear with the petitioner. কিভাবে আপনার দিচ্ছ কেন এসব?
Yes.
After vacation? After vacation?
Why?
Nobody is appearing?
What is your prayer?
Well, practically there is no scope for any interim order, dismissal from a service.
Where is the order?
The order passed by the appellate authority, it starts from page 36 and concluding portion is 41. Disciplinary authority passed an order for feature of the pensionary benefit as usual removal service. I prefer an appeal. Appellate authority.
Please come. The order passed by the disciplinary authority, affirmed by the appellate authority against the petitioner, is impugned in the instant writ petition. Stop. There is no scope for passing any interim order in this matter at this stage. Stop. None for the respondents. Stop. The respondents are directed to file affidavit in opposition within a period of 8 weeks, 2 weeks. Stop. Learned advocate for the petitioner is directed to communicate this order to the learned advocate representing the respondents.
Every service be kept on record.
Yes, yes.
Get.
Service. Buddhababu, service.
Item number 6.
Item number 6, when I'm appearing for the petitioner in this matter. This is in respect to transfer, my lord. 3 times I have been transferred, my lord, due to medical grounds. I came before this honorable court previously, my lord. This honorable court directed me that this representation may be considered on the ground of medical emergency of both mother and the petitioner, with your lordship, my lord. Now, my lord, first time, my lord, being an upper division clerk, my lord, from Ranaghat to Chapra, my lord, I was posted. There I worked. Well, after that, Chapra to Murshidabad.
No, now what is the challenge?
Well, challenge is at page 74, my lord. Lordship will kindly seize, my lord.
74.
Lordship will kindly seize, my lord. Well, 11th March 2026, my lord. Again, I have been transferred, my lord, from Murshidabad to English Bazar, Malda. Well, the only problem is that, my lord, the distance is very much, my lord, because, my lord, my mother is at Krishnanagar, my lord, it's more than, my lord, 200 kilometers. Now, my lord, this is the difficulty, my lord, I approach before this honorable, because this is the second time I am approaching, my lord. And they, my lord, if your lordship kindly sees the divisions bench order at page 766, my lord. sorry, my lord, my page. There is the single bench. After that, my lord, page 69. So, my lord, this honorable court directed for the consideration, my lord. My lord, page 69, my lord. Now, my lord, well, I have annexed all the medical reports, my lord, from 2017. It's not that, my lord, it's a newly I have, my lord, annexed it from 2017, my lord. Well, I have not married, my lord. My mother is a, my lord, only, my lord, she resides with me. My lord, nobody is there to look after him.
See, this is being done not for you alone, for 6 persons.
Yes.
You are serving as the
Disaster management officer.
disaster management officer.
My lord, I am
Wherever
ready.
you have
My lord,
presence
I have
required.
never, my lord, objected to, my lord, from Ranaghat to Chapra, Chapra to Murshidabad. After
It is
that,
a transferable post and you may be posted
know.
anywhere.
I know.
What can
But the
be
only
done?
problem is that, my lord, all the doctors, my lord, who are residing in Krishnamala, my mother is under treatment. My lord, I have annexed all documents since 2017. And my lord, nobody is there in my house. Well, I am not married, my lord. And my lord, mother is entirely dependent on me. Well,
I
only the
understand.
journey is the problem. My lord, and that is the main thing.
I can very well understand, but then what is the alternative?
Well, alternative is let me be posted, my lord, where I am, because I am working from there only. Well, Murshidabad.
It cannot be. The others over there may have similar problems.
But they have not come to before this honorable.
No,
Even they
how
have not
will this
ventilated the
function?
agreements.
How will the department
Well, this is,
function?
may I be very candid before your lordship? Well, this is, I am the victim of this one. As I have approached the honorable court, after that, well, this has been started. And even they have not considered my representation in spite of the order. Well, I
They
have
go before the division bench.
no, I have filed a contempt that is
Then
pending.
yes,
But this is a separate cause of action, my lord. No, this is a separate cause of action.
True.
The
Please.
only problem is, my lord, if they can, my lord, verify, my lord, whether these medical grounds, my lord, I am taking, my lord, whether but they can come with a board, my lord, if a board may be appointed, my lord. Well, I have not affirmed any false my statements before your lordship, my lord. Well, I have annexed all the documents.
The petitioner is serving in the serving as the block disaster management officer. He was posted in Murshidabad, Jiaganj, and he has been transferred to English Bazar, Malda. His home district is Nodia. He submits that his mother is a widow suffering from various old age ailments and undergoing treatment in Chapra, Nodia. There is none to look after and take care of his aged, ailing mother. Paragraph. He was earlier transferred from Chapra to Murshidabad, which he challenged by way of filing writ petition being WPA 9574 of 2023, which stood disposed of by the court on 12th June, on 12th June 2023.
Further, I went to the appellate court, my lord.
Dismissing the same. The petitioner preferred an appeal against the order of dismissal and vide order dated 5th March 2024 passed by the Honorable Division Bench in MAT 1183 of 1189 of 2023 with Can 1 of 2023, the Honorable Division Bench passed order requesting the Director of Disaster Management to reconsider the application of the petitioner on medical ground of his mother, if permissible under the rules. Paragraph. It has been submitted that despite order passed by the Honorable Division Bench, the authority did not reconsider the prayer for transfer of the petitioner to his hometown. Stop. The petitioner has again been transferred from Murshidabad to Malda. Stop. Malda is very far away from his hometown at Nodia, and it will practically be impossible for the petitioner to take care of his mother and continue with his duty simultaneously. Stop. Prayer has been made to consider transferring him at Nodia. Stop. Paragraph. None appears on behalf of the respondents. Stop. On a perusal of the documents annexed to the writ petition, it appears that the transfer order was passed on 11th of March 2026. Stop. Thereafter, there is no representation from the petitioner requesting posting at his home district, Nodia.
Yes. Representation is there, madam.
Where is the representation?
Yes, yes, ma'am.
After March 26? In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply before the authority, highlighting his grievances, annexing supporting documents. Step. In the event such representation is made, the same shall be considered by the director, disaster management, West Bengal, in accordance with the prevailing rules at the earliest, but positively within a period of 6 weeks from the date of filing the representation. Step. The fate of the representation shall be made known to the petitioner. Writ petition disposed.
And only one prayer, madam. On a medical board, maybe, madam, I am ready to face that, madam. I am ready to face that, madam.
What?
In respect to the medical, madam, the urgency and the emergency which my mother is suffering.
Nobody is disputing that.
Madam, what they have done, madam, now they are transfer 125 kilometers.
Cannot.
Madam, I was managing from Chapra to
Take your
Murshidabad.
mother over there.
Madam, impossible, madam. She is suffering from various things, madam. I cannot take her, madam, there. I mean, all the doctors are.
Then at least keep somebody who can take care of her.
Madam, I have tried, madam. If this is Murshidabad, madam, if you lost him, madam, kindly make him, madam.
Sorry, sir. Please call next.
And affidavit of service may be kept on record.
Yes.
Service.
Is here.
Number 2, the advocate appearing for the union is appearing through online.
All right. Item 2. Yes. Item 2.
ওনাকে আনমিউট করুন, ওনা তো মিউট করা।
Please unmute yourselves. The court cannot hear you.
Lordship, I have unmuted myself.
Yes.
Am I audible, Your Lordship? Audible.
The court cannot hear you. Call the.
It may be taken on Monday, Monday.
Monday? All right, Monday.
Because
Not
he is in
today.
Rajarhat, may not come today.
All right, Monday.
Grateful.
This is the report in the form of affidavit, madam.
Kunta?
Item number 1.
It a one. Not today,
Passover. Item number 1 pass over.
দিন রয়েছে তো।
My lord, this is the report in the form of an affidavit, my lord.
Yes, give. Why is it appearing as to be mentioned?
My lord, this application is infructuous, my lord. Already petitioner filed another writ application. This is the order of that writ application, my lord.
Oh, please come. And appears on behalf of the petitioner. Stop the report by the
CISF.
respondents filed in court to be taken on record. Stop. It appears that the cause of action for filing the instant writ petition does not survive any longer, as a final order in the disciplinary proceeding has been passed by the authority and the same is under challenge. And the same has been challenged by the petitioner in a separate writ petition, being WPA 6249 of 2026, which is pending consideration before the court. Stop. In view of the above, there is no requirement of proceeding with the writ petition any further. The same stands disposed of as infructuous.
Item number 142.
May it please, Lordship, I'm appearing for the respondents 3 to 5.
My lord, in this matter, my lord, I am appearing for the petitioner. I have been led by Mr. Kollal Basu. My lord, praying for not today, my lord. He's on legs, my lord, before some other.
Why don't you start? He'll come and join.
My lord, I can start, but my lord, my brief is also not here. That is the only reason I'm facing the difficulty.
Not today.
Much obliged, my lord.
Very deeply obliged.
Now 144.
Dismissed.
One 145.
Dismissed.
146.
Dismissed.
147.
Dismissed.
148.
Lordship, I am appearing on behalf of the petitioner.
$120 leave.
Lordship,
Yes. Give the order that you are relying upon. All right, disposed.
good.
Sir, 144 and 146, I'm appearing on the petitioner.
What can be done? You are not there.
Sir, I was coming from another court from 14. My lord.
Just wait. It will be called on. Just wait. 144, 146. Call the next matter.
Lordship, similar prayer as 148.
All right. Are you there? Both the matters? All right. 148, 149, same order.
Repeat 149.
150.
Same order.
Lordship, in this matter, petitioner praying for unpaid 80% of provident fund along with interest on belated payment of leave encashment and gratuity. Similar,
You have an order?
Lordship.
Let me see. দেখি কি দিচ্ছে।
Mhm.
%80 provident fund,
Lordship,
gratuity and leave salary was disbursed belatedly.
belated.
You got the gratuity
Yes, got what belated manner payment.
and leave salary also you got
So-
belatedly.
Yes, Lordship.
So same order can be passed.
Lordship, only Lordship,
Did you make any representation?
Lordship, representation made on 19 January 2026.
All right. Pradeep. Paragraph 4 take down. A representation made by the petitioner is pending consideration at the end of the authority.
কি order হলো? কি মামলা? ও আচ্ছা আচ্ছা।
Paragraph number 6, directing the managing director CSTC to take steps to consider the prayer of the petitioner
দেখেছিলি তো?
for releasing the balance amount.
দেখি জুনিয়র এ করতে দিই মার্কেটে। এই 3:30 কত থেকে কত অব্দি এখন?
138 থেকে 158।
এখন 150 হচ্ছে। বড় আছে।
হ্যাঁ।
Take down one more paragraph. 7 এর পরে আসবে। Simple interest. No. As the petitioner received the gratuity and leave encashment at a belated date, comma, he shall be entitled to interest on such delayed payment. Stop. Simple interest calculated at the rate of 6% per annum on the
অর্ডারটা কি আছে দেখো তো যাচ্ছে।
gratuity and leave encashment dues shall be calculated at the rate of 6% from the next date of retirement till the date of actual payment.
প্রভিডেন্ট ফান্ড লিভ স্যালারি অর্ডার
The same shall be cleared within a period of 12 weeks from the date of communication of this. Yes, disposed.
No, no. Not only one thing, possibly the judgment shown by your lordship's judgment. There are two separate judges. One deals with provident fund, one with the leave salary amount. This combines both the prayer.
No, not both. He has not got 80%.
That's right.
And he has received his gratuity and leave encashment at a belated date. Only interest will be payable for that.
No, no, I was looking at a different thing. Because one of these matters combines both. Leave salary, part of that 300 days ceiling limit
Yes,
and
yes. Even yesterday, possibly some order was passed. Let us see today if any of the matter is there.
এটা আছে তো।
151.
কি নাম রে?
151.
হ্যাঁ?
Hmm?
প্রসেনজিৎ জানা বলছে। তোর নাম কেসের নাম বল। তাই বল, তোর নাম কেন জিজ্ঞেস কর? কি বিপদ?
Yes.
এটা দিস কম্বাইন্স
Yes.
বলছে প্রসেনজিৎ।
Your Lordship, praying for similar as item number 50 and also praying for
50.
50, 150.
15.
In 150.
Earlier matter, Your Lordship.
150.
But this
150.
this combines two prayers.
Tell me what is your prayer?
Praying for 80% unpaid provident fund
Yes.
related payment of along with interest on belated payment of gratuity and leave encashment.
Yes.
Also praying 120 days of leave salary.
Gratuity and leave encashment. You got at a delayed point of time. That means you want the interest. And you want
Unpaid 120 days of leave salary.
leave salary. That means you got part leave encashment.
That's
For how many days you got?
he has been
180
received
days.
180 days.
You want to order to the আচ্ছা তোর কাছে
Let me see what is the order that you are relying upon. Are you relying upon any such order? Let me see. Pradeep, please come.
তোর কোনটা দিল? বাকি
When did you retire?
Retire on
Ew.
30th November 2025.
এই পণ্যগুলোতে না এই ডেট অফ রিটায়ারমেন্টটা চেক করতে হবে, আমি এগুলো দেখিনি কিন্তু allegation is that he also alleges that his gratuity was disbursed in his favor belatedly. এখানে অ্যাড করুন তো he received he received leave salary only for 120 days. Stop, paragraph 3. He prays for disbursal of his balance 80% of his provident fund dues, comma 120 days leave encashment and interest on the delayed payment of his terminal dues, including provident fund, gratuity, and leave encashment. Not including, but comprising of. Did you make any representation?
Lordship made on 16 February 2025.
Paragraph 4 is just
Sorry, 26, Lordship.
the petitioner filed a representation.
No, demand justice. Demand justice.
The petitioner filed a representation praying for disbursal of his aforesaid dues. Stop, but the same is pending consideration till date. Six, please add. Directing the managing director CSTC to take steps to consider the petitioner's representation. For releasing the aforesaid dues of the petitioner. Stop. Same. Accordingly, the dues. Accordingly, the aforesaid dues. Yes. Disposed.
But as far as that period is concerned, Lordship was directed to be considered, the leave salary period. The interregnum. Lord,
Yes,
may I take your lordship?
yes, yes, certainly.
I'm deeply obliged, your lordship. আজকে 3:30 আছে।
Yes.
Seriously.
I am for the petitioner, my lord.
এটা সেম নয়
I have served my lord regarding guiding harness, approval, only for pending for approval, my lord.
Where
Kindly,
is it?
my lord, kindly see the last annexure, my lord. Last page, my lord, page 40, my lord. They have considered it, my lord, and my lord, the page 42 is, my lord, for sending for approval, my lord. But that is still pending, my lord. From July 2025.
Please come. The prayer of the petitioner for grant of appointment on compassionate ground was forwarded for taking necessary action by the Assistant Director of Agriculture within bracket ADMN, comma, soil conservation, comma, caps D, caps P. এগুলো তো caps. একটু দেখে নেবেন তো, page 41. On 7 July 2025 to the Joint Director of Agriculture within bracket soil conservation West Bengal. Stop. The same is yet to be disposed of by the Joint Director of Agriculture. Stop. None represents the respondents. Stop. Affidavit of service is on record. Stop. As it appears that the matter is pending consideration before the Joint Director of Agriculture for a considerable period of time. Accordingly, the instant writ petition stands disposed of by directing the respondent number 4 to take a decision on the communication forwarded by the Assistant Director of Agriculture, strictly in accordance with the prevailing rules at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated. No, not reasoned order. The fate of the petitioner's application seeking appointment on compassionate ground shall be made known to the petitioner. Service is on record.
I want to please, I'm appearing for the petitioner, Your Lordship.
I am for CST slate.
Your Lordship, this is a matter where the petitioner is a retired employee of the Calcutta State Transport Corporation. He retired on 30th of June 25. He is covered under GPF. He has not been paid his provident fund dues till date, and the interest and the leave salary has been paid belated. So I'm praying for 100%.
You've got
Well, it
similar
has not
orders.
Uploaded, Your Lordship. Day before yesterday, the order was passed.
You GPF contribution.
100% provident fund with interest and interest on the delayed payment of my gratuity and leave salary.
Gratuity and leave encashment interest. All right. Representation is there?
No, Your Lordship.
No representation. All right, disposed. Pradeep, there must be similar order which was passed. Please check.
Here the petitioner retired from service on 31st of July 25. He is covered under GPF. He has not been paid his provident fund till days. So I am praying for 100% provident fund with interest and the interest on delayed payment of my gratuity only. There is no leave at his credit. So interest on gratuity only and 100% PF with interest.
All right. Disposed.
Lordship, here I am praying for retired from service on 31st of July 2025, covered under GPF. I am praying for 100% of my provident fund with interest and the interest on delayed payment of my gratuity and leave salary. That's item number 153.
All right, disposed.
Lordship, here I am retired from service on 30th of November 2025. I'm covered under GPF. I'm paying for 100% of my provident fund with interest and the interest on the delayed payment of my gratuity and leave salary, like the earlier one.
Disposed.
157 also same, your lordship. I retired from service on 31st of July 25. I'm covered under GPF. I am paying for 100% of my provident fund with interest and the interest on the delayed payment of my gratuity and leave salary.
Yes.
Lordship, here I retired from service on 31st of May 2025. I'm covered under GPF. I am paying for 100% of my provident fund with interest and the interest on the delayed payment of my gratuity. No leave at my credit.
Disposed.
I'm grateful, your lordship. No,
Dismissed.
I am for the respondent number 7, my lord.
Record your appearance. Dismissed.
My lord.
Lordship, on indulgence, Lordship, I am appearing for the item of 145, Lordship. It has dismissed, Lordship. Kindly make it not today, Lordship. Or pass over, Lordship, kindly.
What is the matter?
Lordship, I don't have brief, Lordship. Kindly pass over, Lordship.
145?
Yes, Lordship.
Not today. Give your matter. কত ওটা বললো? 144 দেখি 144.
I'm appearing on behalf of the petitioner, my lord. Its matter pertains to the recruitment process with regard to, my lord, excise constable in the year 2021, my lord.
21. Why are you filing writ petition in 26?
It was filed before the my lord.
Tribunal.
Yes, my lord. Before the tribunal, my lord. Therefore,
144.
order was passed in the in that original application, but it is not going on anymore, my lord. The main grievance in this matter is the violation of the reservation policy, my lord. The candidates of reserved categories who has obtained much more marks than the last candidate of the unreserved category has been adjusted in the reserved category itself, and they have not been adjusted in the unreserved category, due to which, my lord, due to which, my lord, we have come before your lordship, because if the reserved category
Please come. The recruitment under the recruitment in the post of excise constable in the subordinate excise service under Finance Department, Government of West Bengal
144.
for the year 2019.
Notice of 2019, my lord, and it
The year
was held on
2019.
2022. It was held, my lord.
Held in 2022 is
No, my lord. My lord. It is notice of 2019, and my lord, the preliminary test was also held in 2019, my lord.
2019. Held in লিখতে হবে না 2019 is impugned in the instant writ petition. না কি দিয়ে শুরু করলাম? Judiciary is the subject matter of the instant writ petition. Is the subject matter of the instant writ petition. Stop. The policy of reservation is under challenge. Stop. None represents the respondents. Stop. In the absence of the respondents, the matter cannot be adjudicated. Stop. Let further notice be issued. Released on 8th.
Much of
service taken on record. 146 is also same.
146 is with regard to the recruitment. 146 is with regard to the recruitment in the post of wireless constables.
The
My lord. Similar, our contention is similar. The
Reservation.
reservation policy has not been maintained. My lord.
which year?
It is, my lord, 2021. It is notice of 2021. 13th February 2021, my lord.
21 or 20, I can see.
My lord.
It's of the year 2020, I can see page 39. Information to applicants
39?
for submission of recruitment. Wireless operator 2020.
Yes, but it was held, my lord. Notice
Maybe
was
held
published
later on.
on. Yes,
Please come.
yes, ma'am.
ওপরে যেটা বললাম 19, এটা হবে recruitment to the post of wireless operator in West Bengal Police Telecommunications 2020. Rest same.
আচ্ছা, এটার ইয়ে দিন না 146
Item number 8 from the daily list.
My lord, in this matter, appear for the respondent bank. The last occasion, my lord, this today is my lord fourth day of hearing, your lordship. They initially moved the application. They took time to file supplementary affidavit. Then again they come up, place the matter.
My lord, Mr. Shomo Mujumdar is appearing and Miss Pandey is assisting him, my lord. Both are on their legs, my lord. I was praying for a short passover, or my lord, not today, kindly.
Passover may not be possible today. So
Well,
it will be adjourned for the day.
Gotcha.
Not today only. Record an order, please. Accommodation has been sought for on behalf of the learned senior counsel representing the petitioner. Stop. In view of such submission, hearing of the matter stands adjourned for the day.
Item number 9.
Madam, for the petition.
Me, I am not holding the button of the state, but the thing is, your lordship was pleased to direct the state to file a report in the affidavit. But perhaps the junior have seized the power, he has resigned from the panel, so it cannot be prepared. And pursuant to lordship direction, the ACMH respondent 6 online.
Who is there online?
Respondent number 6, the ACMH, who was to pass the reason order. He has passed the reason order. See, as the affidavit could not be prepared due to the situation.
This is the matter where petitioner wants the benefit under the memorandum dated 16 September 2011, which says if he has worked as a contractual worker for 10 years,
The peculiar
he's
situation
entitled
today,
to
but I must indicate.
Where is the ACMOH?
He is online, brother.
Yes, ma'am. I'm here.
What is your submission?
Ma'am, I already submitted the rescind order copy to my lawyer.
You are unable to? I cannot hear you. Yes?
Ma'am, hello.
Yes? What is your submission?
Ma'am, I have already submitted my rescind order copy.
What is there? Please mention.
To my lawyer, ma'am, rescind order copy at date 5/5/2026.
You please say what you have mentioned in that report.
Ma'am, on careful scrutiny of documents submitted by the petitioner in support of his cause and those available or not available in the office of the BMO Sagar RH, it can be concluded that Vibhas Devnath is not eligible for benefits under the quoted memorandum of the Finance Department
due to non-availability of proof of 10 years of uninterrupted service, including 240 days per year during the relevant period.
You say that the petitioner does not have any proof of service, uninterrupted service for 240 days?
Yes, ma'am.
You do not have the documents?
No, ma'am.
Where are the documents, petitioner?
Well, these documents, Lordship, are given by engagement letter.
Where are the engagement letters?
Madam. Well, it is P2. Well, kindly come to P2, which is in page 21.
Yes.
These are the photographs of the holder card. Thereafter, certification in 2008 by the concerned hospital, my lord. That kindly come to page 22. This is to certify that such and such, aged such and such, is working as a sweeper. Thereafter, in 2008.
Oh, wait, 1 minute. Working as a sweeper in Shago Rural Hospital from 1st of May 2007.
Yes.
This is given in 2008.
Then 2013, my lord, again, I made my representation.
After 2007 and you obtain a certificate in 2008, you go to 2013. In the midst, you do not have anything.
My lord, I have to take instruction if in midst I have or not. I have. Must have, because I'm continuing, my lord. That is my
Page 22, I can see one. 23.
20.
This is to certify that such and such.
This was in 2008.
Working as sweeper, contractual basis.
Then, my lord, kindly come to 2008. Again, I've given it. Then to 25, চুক্তিভিত্তিক সাফাই কর্মী কাজে স্থায়ীকরণের আবেদন। My lord, here also I write that আমি সাগর গ্রামীণ হাসপাতালে.
You prefer regularization.
Yes, my lord.
Regularization is different. Whether you'll get the benefit of that memo is the subject matter over here.
Then 13 I made, and thereafter, my lord, kindly come to. I have the proof of the salary. This was inversed in my account.
It goes to your account directly?
টাকাটা কি অ্যাকাউন্টে যেত ডাইরেক্ট? Yes, my lord. সব থেকেই যায় ওটার ভাবে? হ্যাঁ? পুরোটা আছে তো? ওরা বলছে।
But then page 65, 9008, this is the benefit you want?
Yes, my lord.
6th of September?
6th of September.
Right. Please come to paragraph 4. It says that you have rendered 10 years of service continuously each year. So 10 years prior to 2011. So you have to show documents from 2001 onwards. Where are those documents?
Well, kindly come. That cannot be. 2007 I joined.
So how, if you join 2007, how will you get the benefit of page 65?
But if I read paragraph number 1, in order to provide security of the tenure, appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual deliberated contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years.
Do you fulfill this?
My lord, yes. 2007 to 2017 I have fulfilled, my lord.
Sir, you want the benefit of 2011. You have to show that you were there in 2011 for a period of 10 years. It's not that in 2017 you'll invoke 2011 memo and then
continued, my lord. This benefits is given continued.
If you do not fulfill the first one, how can you go to the rest?
Now, Lordship, if I come to point number 4, the Lordship has quoted.
This was for the year 2011. And you had to be there from 2001. That is the reason 2011 was issued. Not that 2011 you will take the benefit in 2017. And you'll get the benefit provided you are there since 2001 onwards.
Possibly that the intention of this particular circular was to bring all the casual workers. That's why Lordship kindly come to 4, the remuneration of the casual day-related contractual workers who have not yet completed 10-year service will be equivalent to 75% of the remuneration admissible. So it takes care of those who
only 75%.
who are not in service. So so there was some protection for them also.
For them in 2011. This is of the year 2011.
But this we continue till today. They are giving it, my lord. That is the.
They are giving from 2011. Everything is in connection with 2011. I do not know. Whatever you have got to say, ACMOH, you can pass a formal order and you can communicate that to the petitioner directly. Post it directly to the petitioner so that the petitioner, if he is aggrieved, he can challenge that order.
Okay.
Have you followed?
Okay, ma'am.
Please come. ACMOH Kagdeep is virtually present. Stop. It has been submitted that the report directed to be filed video order dated 6th April 2026 has been prepared and handed over.
The order has been passed. The report has put out prepared.
The report directed to be filed could not be prepared as the learned as none is representing the state on date. Stop. The ACMOH has been directed to pass formal order and communicate the same to the petitioner directly. Stop. The proof of communication shall be placed before this court on the adjourned date. The formal order and the proof of communication shall be placed before this court on the adjourned date, right? Released on 8th June.
But if I get that.
Personal appearance of ACMOH stands dispensed with for the time being.
So in the meantime, it would be placed on 4th June. Well, in the meantime, if I get the order and if I find that it has to be challenged, that can be independently filed before.
Goes without saying. It's absolute fresh cause of action.
Is required not to be filed.
If the order is there, at least, if somebody is there by way of a, yes, if one-page report affidavit is there, it will be there. But then if a fresh cause of action is there, the petitioner will challenge it afresh. We'll see how
Our report remains.
it stays.
Grateful.
Yes, madam, you may leave.
Okay, thank you, ma'am.
Yes, 10.
My lord, on the last occasion, there was a direction to file affidavit in reply to the affidavit in opposition that was served upon us. I've served a copy, my lord.
Yes, what is the matter?
My lord, the petitioner was deployed as a constable cum driver in the central in the CISF since 30/6/2012. He had served in various capacities, and pursuant to an order, and I will come to the specifics of the charge. Pursuant to an order dated 4/5/2023, his service was terminated. My lord, the allegation seems to be twofold. Primarily, the allegation is that he was drunk, he was consuming alcohol, and the secondary allegation is that in the past he had some incidents, disciplinary issues. Now, my lord, the 4/5/20, my lord takes 4/5/2023's order. This is the order that I'm challenging. This is page 261 to 274.
Yes.
It's annexure P5.
Yes, please.
Why this order, my lord?
261.
Page 261 of my application.
Yes, final order.
Fine, that is the final order.
Right.
Subsequent to that, so this order, I submitted detailed representation, etc., but it has been dealt with. I'm just placing this to demonstrate before your lordship that it has been dealt with. But what has been alleged, my lord, if my lord looks at the sequence of events leading to the termination, I was deployed in a for second batch rotational training for the year 2023. During lunchtime, I went to the barracks to eat. However, I did not like the food prepared there. I went outside to a dhaba to eat food of my choice. I was a little troubled emotionally, and I have also admitted, my lord, consumed alcohol in small quantities. Thereafter, I headed back to the township with another member, one Vijay Kumar Dhal, who was severely intoxicated. And I was allegedly, the allegation is that I was found to be intoxicated at 15:15 hours standing at the unit ground during head count. Now, my lord, the allegation is that I am intoxicated. On what basis? No medical is done. Simply on a breathalyzer report, I am being a disciplinary action ensues against me. There is no medical done. The breathalyzer, my lord, takes a look at there is no blood or urine test, no conclusive finding. The report is page 35-36. There is the only thing holding me responsible for my alleged misconduct is that they happened to sniff some alcohol on me, and by way of a breathalyzer test, I was a disciplinary inquiry was conducted. My lord will note my lord, I am covered by this honorable court's division bench of this honorable court's judgment, Narendra Datta Rai versus Union of India, identical situation, my lord. And there, in that situation, the alleged the petitioner, against whom the disciplinary inquiry was conducted, had multiple, as many as 13 counts of disciplinary proceedings in the past. My lord, comes to para 49. Before this Narendra Datta Rai versus Union of India, this is 2018 SCC Online Cal 8613 from my learned friends. Para 49, before imposing major penalty upon an employee, the respondent authorities ought to have conducted the necessary medical tests to come to a definite finding that the employee was under the influence of alcohol, which resulted in his misconduct. The respondent ought to have satisfied themselves that the employee was in such a mental and physical condition so as to deprive him of clearness of intellect and control of behavior, control of himself, which he would otherwise possess, and the said behavior was under influence of alcohol. In the absence of any corroborating piece of evidence, an employee ought not be removed from service. My lord, there are scores of judgments there, and this is I'm coming to the CCS rules as well in a bit, my lord, but there are scores of judgments which highlight that in order for of course, termination is a very disproportionate, it's an extreme form of punishment, it's an extreme form of penalty leveled against me. There are scores of judgments which highlight that in such cases, in identical cases where there is an allegation of intoxication, a blood test, a proper medical test needs to be conducted. There has to be other tests. For example, divided attention test, walk and turn test, one leg stand test. These need to be done. However, the medical examination report of the NTPC hospital where this was conducted, this is the one which I pointed out, I placed before your lordship, this is dated 17/1/2023, page 110, if I'm not mistaken. This demonstrates that breathalyzer test report of NTPC hospital, that was the only thing that was done. In this test, it was found that it was positive. The manual test was 65.8 mg per 100 ml. There was no blood or urine test, and like I said, my lord, that there was none of the other tests was conducted. None of the doctors of the Farakka hospital, there's a NTPC hospital, who examined the petitioner, testified during this departmental inquiry to figure out the exact condition of the petitioner. That is that, and I will bring the witnesses who have deposed before the inquiry committee, and even those witnesses, my lord, none of them testified to the state of intoxication or the fact that whether the petitioner was guilty of any misconduct. My lord, Rule 22 of the CCS rules is very clear. The CCS conduct rules is very clear. It does not prescribe. My lord, we'll need a copy of this. Consumption, Rule 22, my lord, comes at Rule 22. This is page 16. Consumption of intoxicating drinks and drugs. A government servant shall A, strictly abide by any law relating to intoxicating drinks or drugs in force in any area in which he may happen to be for the time being. B, not be under influence of any intoxicating drink or drug during the course of his duty, and shall also take due care that the performance of his duty at any time is not affected in any way by the influence of such drink or drug. B, refrain from consuming any intoxicating drink or drug in a public place, not appear in a public place in a state of intoxication, not use any intoxicating drink or drug to excess. Explanation: for the purposes of this rule, public place means any place or premises, including a conveyance, to which the public have or are permitted to have access, whether of payment or otherwise. My lord, Rule 22 of the CCS rules, and I will explain how the honorable courts have interpreted this rule. Rule 22 of the CCS rules does not prescribe a blood alcohol concentration, alcohol concentration or breathalyzer report to certify intoxication. The only criteria, my lord, is whether such condition affected official duty or discipline or conduct. The benchmark intoxication, as far as the Motor Vehicles Act is concerned, Section 185 of the Motor Vehicles Act, driving by a drunken person or by
Why will you go to the Motor Vehicles Act?
My lord, just because he was a driver, he was employed as a driver as well, just to benchmark intoxication. So, my lord, on that score, the allegation that he was drunk and he intoxicated and he underperformed his duty, or he presented himself in a manner which would deem to be a misconduct, does not arise. Further, my lord, it has been stated in the charge that due to this indiscipline act during the course and duty, he was sent back to FBP Farakka and thus did not complete the rotational training for which he was detailed by this office, and thus failed to perform his duty and responsibility assigned to him. This is mentioned there. This charge, my lord, it does not clarify the specific impact or the harm resulting from the petitioner's odor or alcohol. The page 108, which is the GD extract dated 17/1/2023. This all starts from page 111. It's a typed copy, is 111, my lord. That also does not specify particular acts of the petitioner, only states that the petitioner was found intoxicated at 15:15 hours standing at the unit ground during head count. That is the only allegation leveled against me. And I am terminated as against this allegation. None of the PWs, my lord, I stated earlier, none of the PWs who were examined in the course of this departmental inquiry, and I will take your lordship to the PWs, none of them in their examination in chief or cross-examination by the inquiry officer or the presenting officer deposed that the petitioner, while in a drunken state, disrupted the rotational duty, or fallen by shouting, or used abusive language, or engaged in physical altercation. He was compelled to discontinue his rotational course not on the basis of any medical report, but pursuant to the order passed by the superior. The medical examination report I have already placed, my lord. The NTPC hospital, this is page 110 onwards. The breathalyzer report is part of page 111. My lord, if your lordship takes a look at the deposition of the prosecution witnesses so presented, none.
But then how much can a writ court can look into all this?
My lord,
things?
I do not wish to. I'm just paraphrasing. I'm just paraphrasing for my lord's convenience, that none of these is article, in order to prove the second charge of article, which squarely alleges that there was intoxication, etc. None of the prosecution witnesses testify about intoxication, and I will urge my learned friends to prove me otherwise. And Article 3 charge, my lord, the article of charge 3, that pertains to absolutely isolated events of the petitioner's past and fails to take into account the blemish-free record of the petitioner for the good conduct of the petitioner for 11 odd years or so. My lord, apart from the Narendra Dutt Rai, which I've already placed, which I think squarely covers this scenario, let me place before your lordship another judgment which also squarely applies here. Copy to আমি citation দিচ্ছি। আচ্ছা নিতে চাইলে নিন, দিচ্ছি। This is Munna Lal versus Union of India. This is a three judge bench judgment of the Honorable Supreme Court, 2010-15 SCC 399. Para 3, 4, 5 and 6 are moot. Even here, my lord takes a look at 3 and 4. Fourth, the learned counsel appearing for the respondent submitted that the appellant was found guilty of dereliction of duty previously also, and there was other disciplinary proceedings against the conduct of the appellant. But in the instant case, it was not proved that the appellant was drunk on the day when he was in duty. Evidence was not satisfactory to prove he was found with any alcohol, and he was also not taken to Safdarjung Hospital, etc. In the absence of any positive evidence, we are of the view that the charge leveled against the appellant was not proved satisfactorily. In the absence of sufficient proof, the disciplinary authority should not have imposed such penalty. Here also, it is a disproportionate penalty, my lord. Therefore, the punishment imposed was illegal, and the appellant is entitled to be reinstated in service and is entitled to get 50% of the back wages, etc. My lord, the third, there are ample scores of, I do not wish to burden your lordship with what has already been, it's as a matter of reinventing the wheel. Bachubhai Hassan Ali Karyani versus State of Maharashtra. Again, an SCC judgment, somewhat dated, but proves my argument. This is 1971, 3 SCC 930, para 4, 5 and 6. Here also no urine test of the appellant was carried out. And although the blood of the appellant was sent, this is para 4, my lord, the last part of para 4. And although the blood of the appellant was sent for chemical analysis, no report of the analysis was produced by the prosecution. Here neither is there. There is only a breathalyzer report. Nothing else is there. The question also, the constitutional and the legal question that also comes up before your lordship is that in a departmental inquiry, while a charge is not supposed to be proved beyond reasonable doubt, like a criminal case, but still, my lord, a person cannot be punished on surmises and conjectures. And that also, this is a settled position, Roop Singh Negi versus Punjab National Bank and others. I'm not going to read this out, but the last part of para 23, my lord, identical scenario, the honorable court is stating that the inferences drawn by the inquiry officer apparently were not supported by any evidence. Suspicion, however high, cannot under any circumstances be held to be a substitute for legal proof.
Which paragraph is
this? Is the para 23, the last part of the paragraph.
Yes.
And my final submission is that, my lord, your lordship has this honorable court is justified under Article 226 jurisdiction to interfere even in the quantum of punishment imposed upon by the petitioner, because it is disproportionate by any by any stretch of imagination, termination cannot follow from a simple matter of alleged intoxication. Even though I admitted that I drank alcohol, I have admitted it. Even in the I have made representation to that effect. But it cannot be by any stretch of imagination. It cannot be it cannot lead to a termination. That is all for now. If my learned friend has any submission, I will respond.
You just show me your service records, not service record, the rules, where there is a requirement of taking any other medical test apart from a breath analyzer test.
My lord, this is not coming from service. This is not coming from the CCS rules, but this is coming from a plethora of judgments.
You cannot rely upon, the authority cannot rely upon the breath analyzer test. Where is this judgment?
But my lord, just hypothetically to...
Don't go to hypothesis. Show me something.
My lord, my lord, just hear me out for one moment. Again, hypothetically, my lord, if there was XYZ test were done, and if I was I was found to be I was found to be, I mean, the report was negative. Even in such cases, my lord, my learned friend could not have taken umbrage under the fact that there is nothing in the CCS rules to justify this. So the fact that the rules is not subject to being corrected by your lordship, the rules, because I do not think even my learned friends will be able to demonstrate that there is anything in the rule that says that XYZ test has to be done to demonstrate that someone was intoxicated. I will be candid that I have received, my information is from the plethora of judgments, and your lordship is very correct. But if your lordship insists on knowing this, can your...
Not insistence. Thing is, at least they have this one report which suggests that you were under the influence of alcohol.
Through breathalyzer test.
And you admitted consuming it?
I admitted, yes.
Right? Very well. Yes.
Sorry, Milord, today some difficulty to me. Although, Milord, I am only submission, Milord. The petitioner was served with charge. Then, Milord, on the basis of the charge, a departmental proceeding was initiated by issuance of charge. Inquiry proceeding was held.
No, everything is all right.
Everything was right. Now, Milord, if we go to the judicial review of this, they have lost in the appeal after final order. They preferred the appeal, and subsequently, Milord, the review application was filed. That was also rejected. Now, question, Milord, the judicial review. If we go to the judicial review, entire matter, Milord, the charge which was happened to be established by all the authority. The authority means, Milord, final order was passed by the disciplinary authority, and that was supported by the appellate authority and revisioners. Your lordship, can you provide me, because I have handicap with not copy of all the judgment, Milord, we shall produce your...
But these are very settled provision. That's
that's it. Judicial, Milord, I have appeared so many...
If you want to come prepared, I'll give you time.
Yes, on Monday, I will produce all the support of my contention, Milord. Everything will satisfy the court.
Very well, please come. Affidavit in reply on behalf of the petitioner filed in court today is taken on record. Stop. Learned advocate representing the petitioner commences and concludes argument. Stop. Learned advocate representing the Union of India seeks time to come prepared. Stop. List. I give you next Friday.
Friday? Next Friday?
Next Friday.
Friday
15th. 15th. So you've got enough time to come prepared.
And my lord, you asked, your query was whether there's anything in the CCS rules that's spelled.
Personal difficulty on 15. That's why, Milord, I am paying for only Monday. If next Monday.
No,
or
Monday it will not be possible. It won't be possible.
Friday, Milord, some personal difficulty. That's why, Milord, I have to attend the others outside. I will not be here.
In that case, on Wednesday.
Good.
13th.
13th.
13. In case you are in difficulty, your junior is there, he'll continue.
No,
Right.
I want to get the chance to argue this.
Yes, yes, please.
Reply copy to video.
এর সাথে না লাগিয়ে রাখতাম পিন করে।
May I please lordship, I am for the petitioner. This is my exception to the report filed by the respondent authority. What happened in this case, my lord, I have crossed the hurdle up to, my lord, physical efficiency test. Thereafter, the detailed medical examination board found me unfit on the ground of post-operated, my lord, page 24 of my writ application P4. My lord, post-operated comes, something is there, left grade 3 varicocele for further endoscopy. Page 25 is the review medical examination test. They have found grade 2 varicocele. USG opine, my lord, opinion was there, but no USG report was submitted at the time of review medical examination.
Page 25 is very illegible. Have they mentioned it in their report?
Yes.
Varicose vein, what is the ground?
My lord, grade 2 varicose.
Grade 2 varicose vein.
Yes, ma'am.
Grade 2 varicose.
Left grade 2 varicose.
Where is it mentioned? Acha, ঠিক আছে.
Yes,
My
that
lord,
is the annex part 2
yes, ma'am.
of the exception.
Not varicose vein, it's
Varicocele.
very, I cannot pronounce. I do not know how it is pronounced.
Varicocele. Well,
Whatever it is.
It sounds like varicocele. It sounds like.
Whatever.
The doctor says varicocele. Sounds like varicocele. But by spelling, if I go through spelling, it sounds like another.
Yes, then.
My lord, the page, my lord, 25 is the rejection order. My lord, I have prior to participated in the year 2023 examination, I have operated. It was there. Operated. And my lord, it is pertinent to mention that on participation of this year selection process, I got myself assessed from the Chennai Vellore Hospital. That copy I have annexed to you, my lord, in my lord, exception to the report, last page. My lord, here also page 15, here also indicates that I have, at present, I have no such varicocele. My lord, normal studies. Here also I have annexed with my writ application, page 26. My lord, doctors of the Murshidabad Medical College and Hospital also conducted a color Doppler test, USG test. Thereafter, after everything, going through everything, the surgical doctor opined there is no need of my lord, surgery point of view. My lord, patient is fit from the general surgery point of view. My lord, the another report was I annexed. 3 report answer. Moreover, I pray before your lordship, prayer A and B, I should not pray, my lord, praise before your lordships. Prayer C, I want to praise. Today, I am withdrawing the prayer A and B.
A and B, what is there?
Prayer A is setting aside the review and DME order, and prayer B is the declaration for medically fit on the basis of the.
You want re-examination?
Yes, I want to praise the re-examination. My lord, here, my lord, exception, my lord, their report, they have not followed the guideline, the specialist
Which
opinion.
Guideline?
Yes, that I have annexed, my lord, in with my exception.
অনিমেষ বাবু, এই ঘড়িটা চলছে না।
clause page 13, clause 6D.
13 of? 13, page 13 of?
Page 13 of my exception.
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 Yes.
Page 13 is the clause D, 6D. That the specialist opinion. After obtaining the investigation report, they should.
Specialist opinion in case of any doubt. If there is no doubt, why will a specialist be
There is
considered?
doubt, my lord.
Doubt, it has to be in the mind of the doctors.
Yes.
The doctors have not expressed any doubt.
My lord, DME grade 3 post-operative. As I admitted that I have done my operation much earlier to participate this examination, they have first make a doubt because they have not investigated anything in the detailed medical examination. That's why this ground has been assigned that post-operative grade 3 varicocele. For
No,
further
please come.
investigation, they refer this.
No, please come.
Rejected.
Please
My
come.
lord,
The
if your
petitioner
lordship spare me
participate.
for
Another what?
my lord, clause D and my lord, clause 8.
8.
Clause 8 of the page 14.
Page 14, 8.
14, 8.
The same has been considered yesterday, my lord. My lord has considered yesterday this same type of matter.
8. What is there in 8? Few examples to reiterate and bring out
That the specialist opinion is to be taken. Here, no specialist opinion. Another thing, mother. Mother, kindly come to page annexure 3 of the exception report filed by the respondent authority. This report was given taken from the TISM diagnostic center. It suggests my left testis, epididymis, and scrotal is everything is normal. Only indicate left grade. On the basis of I am putting this question to myself, under which they have this radiologist. This is also a radiologist. He come to a conclusion that left grade 2 varicocele, and this report has not been given at the time of review medical examination to me.
Now you've known that this is a problem.
If that be so, if the thing, but the document supplied to me, I can challenge there that this document is not the proper document. On March 2025, the reputed hospital I diagnosis myself, and the radiologist says that everything is normal, study. It cannot be. This is my point. For that reason, I am praying before your lordship. Kindly send this matter.
The petitioner participated. ওই CAPF এর যে অর্ডার গুলো হয় না DME ওটা এইটাই করবেন। আচ্ছা, the disease is দেখুন left grade লিখুন তো left grade Roman 2 VARICOCELE। ঠিক আছে,
পার্সোনাল কারণে আমার কোনো অবজেকশন।
তারপর ওই petitioner got himself checked from other hospital, সেই সব প্যারাগ্রাফে থাকবে। The petitioner presently presses for a re-examination to be conducted. Submission is that as per the medical guidelines for review medical examination in CAPF, the review medical board ought to obtain opinion of concerned specialists or super specialists of government medical college and hospital. It has been submitted that the specialist opinion was not obtained. In such a situation, the petitioner ought to be sent for re-examination, as all the medical reports that he obtained from the other hospitals, suggests that the petitioner does not suffer from any disease for which his candidature may be rejected. ঠিক আছে? তারপর রেসপন্ডেন্টস এর রিপোর্ট থাকছে, এখানে লিখুন রেসপন্ডেন্টস। The respondents in their report have mentioned that as per the guidelines provided for review medical examination and as per the revised uniform guidelines for recruitment examination of caps INGUINAL region and genitals, এই পাতাতে না বানানগুলো দেখে নেবেন, a moderate to severe degree of VARI COCELE on the left side, even without any testicular atrophy, is a ground for rejection. Step. Relying on the guidelines, comma, the candidate was declared unfit by the Review Medical Examination Board. Step. The report of the ultrasonography has been attached to the report. Step. According to the authority, comma, the medical examination was conducted in consonance with the provisions contained in the uniform guidelines for recruitment and as the petitioner has been found to be unfit, comma, accordingly his candidature stood rejected. তারপর যে ইউজুয়াল অর্ডারটা আছে না এটা দেবেন, আর একটা প্যারাগ্রাফ লিখুন, the prayer of the petitioner for conducting re-examination cannot be allowed as it does not appear that there was any doubt in the mind of the expert doctors who examined the petitioner with regard to his medical condition. Stop. Had there been any doubt in the mind of the doctors, or if the report obtained by the expert doctors of the authority was contradictory to each other, comma, then only the question of obtaining further specialist opinion may arise. Step. This is not a case where there is any doubt with regard to the medical condition of the petitioner. Step. All the expert doctors who examined the petitioner were of the same view that the petitioner suffered from ওই যে ডিজিজটা বললাম গ্রেড 2 ওইটা, ঠিক আছে? In view of the above, the relief sought for by the petitioner cannot be allowed. The writ petition fails and is hereby dismissed. এই exceptionটা আজকে ফাইল করেছে, please keep this on record.
One submission I left, can it be considered? Page 8 of the guideline, kindly have it. Page 8 of the guideline, bottom portion, the page marking is there. My lord, clause 7E. It is mild. My lord, it is not the case that the having varicocele, they are not accepted. My lord, I missed that submission. It is the case of another submission of the petitioner is that, my lord, mild varicocele, they may accept if vain are palpable after
My lord, the reply is in the report, my lord. Report last page. My lord, this grade 2 is not mild but moderate.
Yes, it's a
My
moderate.
lord, my lord, we'll find out on the last page
Grade
of
2
the
is the moderate.
Yes, so this is a
Moderate,
Moderate is the
mentioned.
moderate
yes.
is the
Mild maybe, but moderate and acute, severe are not.
Ah,
So this is last page of the report.
yes, moderate.
Yes.
Mild is grade 1. Acha,
Yes.
initially
And this is not mild.
it has also been submitted that mild variocell is an acceptable defect, and the petitioner ought to be given the benefit of the same stuff. According to the authority, the condition of the petitioner is not mild but moderate, which is grade 2, and mild is grade 1. এটা একটা paragraph হয়ে যাবে।
oblige, your lordship, my lord. Next matter, item number কত থেকে কত হয়ে যাবে? My lord, 12 to 19.
এটাকে সরান। Yes.
My lord, item number 12 to 19, I prepared the exception, but some of them wants to come today. My lord, in morning they called me. But
You
it
want
not,
time?
some
When?
extension. Well, kindly 2 weeks time maybe.
2 weeks?
Otherwise, the situation will not be normal for coming there
Okay,
from
ঠিক আছে।
interior village.
12 to 19 on the prayer made by the learned advocate for the petitioner seeking extension of time for filing the reply.
Lot 12, 13.
Hearing of the writ petition stands adjourned.
13,
Stop.
14, 15.
List on 8th June. Stop. Reply may be circulated prior to the adjourned date.
Much obliged, your lord.
One by one, please call so that the respondent's appearance may be recorded. 12th appearance.
12th, I'm appearing for that.
All right, please give appearances.
13, I beg to appear on the applicants. 13, 14, and 15, my lord, all through.
13, 14, 15 appearance.
But ये दीजिए सुमन, ये दीजिए। 13, 14, 15 to March. 13 to 15. March.
I appear for that.
All right.
I appear. I.
19, Mr. Ramchandra Agarwal is appearing on behalf of the.
Anyway, nobody is there. They do not record anybody's name.
Much obliged, your lordship. Grateful to lordship.
To 75 তো ঠিক আছে কেউ কি আছে
My lord, I am for the respondent, my lord.
All right. His name will be recorded.
My junior, my lord, Anjan is also there with me, my lord.
Your lordship, I am also there.
Anjan Chakravarti, my lord.
Yes, your lordship.
All right.
All right.
Your lordship, I am what should you have appearing?
Much obliged, my lord.
Yes, yes. And next to the court number 38 only.
Yes. 235. Yes.
275.
275. 2015 matter.
Yes, my lord, very old matter. It was dismissed for default.
Dismissed for
There-
default.
And
Now
thereafter it has been restored.
restored.
My lord, in spite of direction by this honorable court, no affidavit in opposition has been filed by the North Bengal State Transport Corporation. It is for regularization, and my lord, it will appear from the record that they have been working since 90. From time to time, contractors have been changed, same persons have been working, and my lord, they have been the disciplinary proceeding has been taken by the North Bengal State Transport Corporation directly, my lord, but they are still, by direction of this honorable court, it was directed that their case should be considered by the chairman as they failed to file any affidavit in opposition on earlier occasion. They did nothing simply on the basis that they were not regularly appointed. It has been rejected. Kindly see the order and therefore our representation.
Should it be heard in the absence of the respondents?
Lord, that is the difficulty because the panel has been
No, but then this is NBSTC.
NBSTC. My friend.
This is not the
No,
state.
yes.
Please intimate your other side. None appears on behalf of NBSTC. Stop. Let notice be served. Released on 8th of June.
I know. With my note.
কেউ নেই ডাকুন তো
the daily list hearing matter.
66 and 67.
On point shoulder. Well, the arguments have been concluded, but we wanted that we shall reply to the argument advanced by the London lawyer for the state.
Yes. ঠিক আছে থাকো।
We wanted that the argument advanced by the London lawyer for the state and the London lawyer for a de facto would be answered by us. But the first point, which was raised by the London lawyer for the state, that this writ application is not maintainable in view of the fact that this is under Article 223 of the Constitution of India. As those 4 applications, 3 of Shiksha Sharni and 1 of HON'BLE has ended in a charge sheet. And therefore, petition under Section 226 of the Constitution of India is not maintainable in view of Nita Singh's judgment. Well, may I place Nita Singh's judgment to your lordships?
Which judgment?
Nita Singh, Supreme Court.
All
Nita
right.
Singh judgment.
It was placed earlier.
My lord, nobody is presenting state today.
He is giving his reply.
But the judgments, he's placing judgments today.
No, not new ones.
Yeah, he wants to place new judgments.
No, Nita Singh's judgment. You have already placed. And you have said that it is not maintainable.
The private respondent all along tried to delay the matter on each and every occasion, if I can correctly remember.
One day, 2
No, sir, your the order sheets will say how many dates you took. No use making all those stories over here.
Can you have a look at Nita Singh's judgment? We have got extra copies.
No, don't give extra copies, then I'll get jumbled up. If it is here, then I'll find it out.
I'm grateful to you.
আচ্ছা ওই পিটিশনার আর রেসপন্ডেন্টের জাজমেন্ট আলাদা
It has been placed by the state.
পিটিশনারেরটা দিন
Extra copy.
এটা কাদের এটা স্টেট এটা পিটিশনারের তো হ্যাঁ এটা পিটিশনারের ঠিক আছে হুম
অনেকটা দাগ দিয়ে আসি কিন্তু অনেকটা দাগ দিয়ে আসি Nita Singh and others.
ওই উল্টাতে ঢুকে গেছে ইয়েস এটা স্টেট দেখিয়েছিল ইয়েস ইয়েস
Kindly come to paragraph 3 of the said judgment.
Paragraph 3, yes. Yes.
We have no doubt in our mind about the controls of jurisdiction of a high court. When a challenge is presented asserting that the implement FIR ought to have been caused on the settled parameters. However, sight cannot be lost sight of the settled legal position. That is entirely within the jurisdiction of a high court. Whether to interfere or not, when other remedies are available. If during the pendency of a writ petition under Article 223 of the Constitution of the High Court, when an FIR is challenged, the investigation is completed, the charge is filed, in pursuance whereof the competent criminal court takes cognizance of the offence. The court would be disabled in proceeding with the writ petition going to a judicial order having intervened. We can positively refer to the decision of the bench of 3 judges of this court made on a reference in
Radheshan versus Chovina, while disapproving in the view expressed in Surjadevi Rai versus Hassan Chand, it was held that the judicial orders of the civil court are not amenable to the jurisdiction under Article 226 of the Constitution, and that jurisdiction under Article 227 is distinct from jurisdiction under Article 226. We may also note from such decision that upon considering decisions of highway authority, a principle of law was laid down. A challenge to judicial orders could lie by way of an appeal or a revision or under Article 227 of the Constitution, but not by way of writ under Article 226 and 32. But that was the contention of the landed lawyer of the state, or the state. But later on, the same honorable judges of the Supreme Court, in the case of Uddunno Pranjal Kulkarni, possibly the reference has been given by the state to your lordship, I don't know. 2025 Supreme Court cases online, SC. 19 page 1948. The answer has been given in the next judgment.
25 SC, I do not find from the actually স্টেটেরই তো বলছে yes পুনিত বেরিওয়ালা
yes
হুম
প্রদ্যুন্ন প্রাঞ্জিকা কুলকার্নি
25 SCC online SC 983
no 1948
1948
this one. Copy down.
আর কোনো জাজমেন্ট নেই তো সব জাজমেন্ট এখানেই আছে তো
সেগুলো নেই তো নেই তো আমি জানি জানি তো আমি পড়ে আছি
was that referred by the state council?
I don't know, I cannot remember, but they are possibly referred, but I can't remember. They have referred, but they have referred. I'm told that they have referred.
আচ্ছা yes it's here পুরো ফেরত দিয়ে দিন yes
Kindly come to paragraph 5 of the same judgment, but the same judge, by the same honorable judges, Maharajasi Dipankar Datta and P.K. Mishra. Paragraph 5. But the answer has been given here. Order in Nita Singh relied on by the Bombay High Court. This was passed by us. Since a question has been raised as to whether the ratio of the decision in Nita Singh has correctly been applied by the Bombay High Court while disposing of the writ petition of the petitioner, the need has arisen to clarify the point. There is a distinct factual discriminatory between the writ petition presented before the High Court of the Judicature of Rabat, from which the special writ petition in Nita Singh arose, the present writ petition out of which the special writ petition arises. The writ petition in Nita Singh was only under Article 226 of the Constitution, as evident from the first sentence to the relevant order. Moreover, a bare reading of paragraph 8 thereof reveals that the relevant bench's jurisdiction under Article 226 of the Constitution or Section 482 of the Code of Criminal Procedure had not been invoked. Further still, the last sentence of the first paragraph records that cognizance of the offence has been taken by the relevant criminal court. It is in such circumstances that we had the occasion to uphold the order under challenge But Allahabad High Court, advised the writ petition only under Article 226 of the Constitution was held to have been become infactual by reason of subsequent events, relying on several authorities, pronouncements of the subject court, including constitutional bench. Paragraph 8 is very important. Can you see? However, from the preamble of the writ petition filed by the petitioner before the Bombay High Court, it is evident that the same sought to invoke the twin jurisdiction under Article 220 of the Constitution and Section 520 of the BNS for having the FIR clause. Section 520 means 482 of the Code of Criminal Procedure. It is true that the police report had been filed on 14 May upon completion of investigation of the FIR, but whether or not cognizance has been taken by the jurisdictional magistrate is not too clear for the impugned order instructed above. So long cognizance of the offence is not taken, a writ or order to close the FIR charge sheet could be issued under Article 226. However, once a judicial order of taking cognizance intervenes, the power under Article 226 do not available to be exercised. Power under Section 528 BNS was available to be exercised to close not only the FIR charge sheet but also the order taking cognizance. Therefore, when the charge sheet has been submitted, the cognizance has been taken, therefore, it only the adding of section 482 or the new code of 520 of the code, provided the same is placed on record along with the requisite pleadings, to assail the same in a strong case for such causing is set up. Significantly, it was reasoned by us in witnessing the judicial order not being amenable to challenge before the High Court under Article 226 of the Constitution, and there being no prayer either under Article 227 thereof or Section 482 CRPD, the Allahabad High Court was right in holding the writ petition under Article 226 to have been rendered infructuous. However, in the present case, certainly the division bench could have examined the grievances of the petitioner for quashing of the FIR, together with the charge sheet following it, as well as the cognizance taking order, if any, since the jurisdiction under Section 528 was also invoked and relief claimed could have been suitably molded subject of court to the requisite satisfaction of the court. The order of quashing is warranted on facts of circumstances. Therefore, it's a that just only, nothing more. The second case, my lord.
But then in the instant case, the charge sheet has already been filed.
Charge sheet has been already filed.
Cognizance taken.
In all the cases. And therefore, my lord, only adding of section 227 or my lord 482 of the Code of Criminal Procedure or the new section 526
28.
of the
That is not here. 422 you have not prayed for. It is only
483 is not there. Therefore, I can my lord, just add it, nothing more. Therefore, writ application is always maintainable. It does not change the color and character of a writ petition. According to Supreme Court, you just invoke 482 or Article 227 or the new section of the Code of Criminal Procedure, that is my lord 528 of the BNS. And therefore, if we add my lord section 482, 226 along with 482 in the cost title as well as in the prior portion, or the writ application is maintainable in the Supreme Court judgment. No prejudice is caused to anybody else. Therefore, the state's reply, this writ application is not maintainable, is not correct.
all right.
Until judgment running. And my lord, today, my lord, I have not got this judgment. There is one 7-bench judgment of the Supreme Court.
One?
7-bench judgment.
All
7-bench
right.
judgment of the Supreme Court.
Huh?
If a man's fundamental right is curtailed, slight mistake does not matter. It can be clarified or verified or corrected by the court itself. And I have got a 7-bench judgment. Not today, sorry, my lord, I have forgotten to bring that. I can show to your lordship. 7-bench judgment of 1988. My lord, this is my first answer. Second answer, my lord. My lord, the state or the de facto complaint, my lord, has not submitted anything or may not stated anything so far as Can 4 of 2025 is concerned. So far, we have filed the Can. They have not answered anything excepting that. But they should have answered.
No, their primary submission is that the writ petition is not maintainable.
Very well. This is
If-
maintainable
and
by
this is the state as well as the private respondent's sole submission. State has mentioned a lot of things, a lot of judgments relied upon, but private respondent has not mentioned anything apart from the fact that the writ petition is not maintainable. There is the criminal jurisdiction, alternative remedy available. You should go there. This
Very
is
well,
the only thing.
Madam, we have answered, madam. According to our ability, we have answered. Normally, it is up to your lordship to decide in view of the Supreme Court.
All right. Do you want to place that 7-bench judgment?
Yes, madam, I want to place.
All right. And at the same time, I would require a very short written notes of argument from you.
Yes.
State will not be here, but then you can also file. Not the voluminous ones. Not more than 1 or 2 pages. Not more than that.
I'll precise it.
Because all your judgments are here. You did not cite any judgment. It is only the petitioner and the state. Whatever the judgments you all have relied upon is all here segregated. You can prepare this short notes.
I can always.
Right? I would like you to take some time, take the vacation, and you come back with the written notes.
I'll get to that. No problem.
Learned Senior Counsel representing the petitioner concludes argument. First Friday after vacation?
Yes, yes.
List
At the
on
top, but at the
12th.
top.
2 p.m. hearing will be taken up.
2 p.m. at the top, madam. Otherwise,
Yes, yes, first matter. No, because only for submission of your written notes of
course,
argument.
madam, I shall do.
Written notes of argument shall be filed by the parties on the said dates.
I shall place the 7-bench judgment.
All right.
Can you record that?
2 o'clock যেমন থাকে হয়ে যাবে.
I shall only place the 7-bench
All right,
judgment
all right. You place the
in
court
my
date
written
here.
notes of argument.
All right.
I'll get to it. Very well, madam. Wish you a happy summer vacation.
Oh, so soon?
Why not?
We still have 2
I
weeks
think
to
my
go.
has already planned it.
2 weeks to go.
I think my has already planned it. Something somewhere where is cooling. I'll get to it.
Item number 68 and 72. 72.
68 to 72, are you there? Union of India.
I am for the petitioner.
Yes.
I am for the petitioner in person.
Bring the injunction, my lord, for long time, long period, my lord.
70. My petition, my lord. My lord, my learned friend is saying that he's suffering from it. My difficulty today is I missed to bring the decisions which I seek to rely upon. It is
But
my fault, entirely my fault.
Let him start, my lord, his submission, my lord. Accommodation can be given on the next date for submission of the judgment. Because basic, my lord, the 3 points, whether.
Let him start.
Yes, my lord.
Yes.
My lord, the writ petitioner is a tenant challenging the notice of dispossession issued by the district magistrate under section 14 of the SARFAESI Act. The contention of the writ petitioner is that the notice which was issued on 28th January 2025 under section 14 by the respondent number 3 is not tenable since it does not reflect the actual status of the property. The notice has not even been issued in his name. Whereas the tenant, the writ petitioner, is in possession of the property long before the mortgage was created. Long before. My learned friend's client has used the affidavit. Affidavit does not reflect when the mortgage was created, but it was 1960s.
Mortgage was created.
My tenancy.
Your tenancy.
My tenancy is from 1960s. Those documents are there with the writ petition. Secondly, the tenancy is covered under the West Bengal Premises Tenancy Act. Thirdly, the tenancy, I have filed a suit for declaration of tenancy against my erstwhile landlord. And that suit has been decreed in my favor.
When?
2014, I think.
2014.
I'll show this.
And when was the mortgage taken? You do not know.
I do not. Bank was obviously not a party to that suit because I had no knowledge. Then Lordship, in this backdrop, Lordship kindly comes to the impugned notice, which is at page 352. Annexure P9.
Yes.
The notice dated 28th January 2025, issued by Union Bank of India. Lordship kindly comes to last but second one, Envision Builders. 164A SP Mukherjee Road, and second column is also Envision Builders, 164B SP Mukherjee Road. These two properties, Lordship kindly turns the page. I am not concerned.
You are not concerned.
I am not concerned with the, at page 353, there are 3 properties described. Property 1, property 2, property 3.
Notice to vacate.
Yes. I am not concerned about the first property. Property 1.
Diamond Harbour Road.
Yes, I am not on that.
Yes.
I am only on property 2 and property 3. Roman 2 and Roman 3.
Govind Kaur and Gurdeep Singh.
I am not Govind Kaur or Gurdeep Singh. I do not know who they are.
All right.
All that piece and parcel of Bastu land measuring about 2 kata, 5 chatak, 5 square feet, together with the structure building thereof being premises number 164A SP Mukherjee Road, PS such and such. Property stands in the name of Envision Builders.
Who are you? You are not Envision also.
No.
All right.
Property 3, all that piece and parcel of land measuring about 1 kata, 15 chota, 40 square feet with a structure building thereon being premises number 164B SP Mukherjee Road, Calcutta 26, in the name of Envision Builders. So
Who is your landlord?
my landlord is, I'll show my landlord is Worship kindly comes to page 271.
Isha Bhattacharya.
Esha Bhattacharya
Gursharan Singh Sethi.
and Ravinder Pal Singh Sahani. These two individuals were disturbing my possession, which prompted me to file this suit for declaration and injunction, saying that they have become the owners. No atonement took place ever.
Who was your landlord?
My landlord was Esha Bhattacharya.
Isha was your, and this 2 and 3 were troubling you.
Were troubling me.
All right.
So therefore, I filed this suit and I got the decree. Lordship kindly comes to page 277, my prayer. 2013. I filed it at 2013.
Isha resides in the US, right?
Yes.
2 and 3 partners of Envision.
They are partners of Envision.
No letter of atonement given.
No letter of atonement ever given.
All right. How did you pay rent to Isha?
Rent control.
Since when?
My rent control challans are all annexed.
62 onward. 862.
No. Rent control. Lordship kindly sees the rent receipts which I annexed from page 62 onwards. The first rent receipt is of October 1967.
Which page you said?
Page 62.
290 থেকে আপনার ইয়েটা
আমি আগে অরিজিনাল রেট
Gauranga Malakar.
Yes.
He is the Dilip Malakar must be the son.
Yes. Gauranga Malakar was the original
All right.
tenant.
This is for the year.
Once Lordship kindly sees the premises number 164B.
Premises number 164B. A was not there.
A is, I'm showing the separate rent receipt.
All right. And this is only garage.
Yes, a small portion. I run a jewelry shop.
All right.
There is a small jewelry shop at 164A and the workshop is at 164B.
164B, it is mentioned in page 353. It is 1 kata, 15 chitaks, 40 square feet. You are not occupying the whole thing. You are occupying a portion.
Only a portion of that. Only a portion. And so my first rent receipt is of October 1967, pre-mortgage.
Yes. And in 164A also, 2 kata 5 chitaks, you are not occupying the whole thing.
Not its entirety.
Only a portion.
Only a small portion. That photograph is also at the end. Lordship may kindly see the last page.
All right, doesn't matter.
And then I have started depositing with the rent controller.
295.
From page 295, my lord kindly says.
Page 62, you showed me the 164B rent challan.
Yes.
And where is the challan for the other one?
Yes, my lord.
Sir, A হচ্ছে
Oh, 176, 341, 176.
176. 176 is bank statement.
341.
No, no, rent receipt দেখাতে হবে।
41, 342.
170.
No, 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 that's not
341, 341.
The Indian Bank passbook details.
My lord, kindly comes to page 341.
341.
This is the rent control deposit.
Landlord details. Malacca.
Plus you got
Yes.
kindly sees 164 in respect of 164A. I am depositing the
Yes.
rent control challan.
164A for the month of February 2014.
Yes. 342. Then that continues from 341, 342 like that.
Did you take this on rent in 2014? It must be prior there.
Much prior to that, because that was 164A is my jewelry shop. 164B is in the back portion, which is my workshop. I'll also, I think rent receipts are also there. Rent receipts are also there.
All right, next day you'll show.
Yes. So, and now Lordship kindly comes to the decree 282 at page 282.
And the suit was in respect of both the premises?
No, 164A.
All right.
Lordship kindly sees it starts at 282. This is a suit for declaration. Lordship got it?
Yes.
This is a suit for declaration and injunction. It is the case of the plaintiff that he is a monthly tenant under defendant number 1 in respect of the suit property where he carries on his business. The defendant number 1 is residing abroad and she has authorized measures Talbot Asset Management and Restructuring Private Limited to collect the rents from the plaintiff, and the plaintiff has been paying rent all throughout against the rent receipts. The defendant number 1 by her letter dated such and such informed the plaintiff to pay rent to Sri Indrajit Bhattacharya, and according to the plaintiff paid rent to him against receipts, but said Indrajit Bhattacharya subsequently refused to accept the monthly rent for which the plaintiff has been depositing rent before the rent controller. The defendant number 2 and 3, claiming themselves to be authorized persons of defendant number 1, have been creating disturbances in the use of the suit property by the plaintiff, though no letter received by the plaintiff from defendant number 1 claiming them as authorized persons. Therefore, there is no letter of atonement, at least not on record. The defendants have been disturbing in the peaceful possession of the plaintiff, and hence this suit. Summons could not be served upon the defendants in ordinary manner for which the paper publication was made. The defendant number 1 and 2 did not appear. As such, the suit proceeded ex parte against them. Video order number 13 dated such and such. The defendant number 3 appeared on 26th February 2014 but did not file WS. Kindly Lordship sees. Appeared but did not file WS, for which the suit proceeded ex parte. The plaintiff, in order to prove his case, adduced the following: 3 trade license, electricity bill, rent bills, rent receipts, 12 rent control challans and Exhibit 5 collectively. The plaintiff in the suit has claimed his tenancy right in respect of the suit property. The plaintiff, in order to prove his tenancy right, has filed the rent bills and rent receipts issued by the authorized persons of his landlord, which shows his tenancy right over the suit property. Documents also proves that the plaintiff has his business in the suit property. The evidence of the plaintiff in that respect has remained uncontroverted and unchallenged, and I'm inclined to accept the same. And as such, I find the plaintiff is entitled to get a decree of declaration of his tenancy right over the suit property. Declaration that he may not be ousted from the suit property without due process of law. My lord, this is what I'm insisting on. There is a decree which says I cannot be ousted without due process of law, passed by a competent civil court. and permanent injunction restraining the defendants from interfering with his right over the suit property. The plaintiff has also prayed for a decree of mandatory injunction directing the defendants to keep open the bath and privy tap water connection and the 3 feet wide common passage at the ground floor of the premises of 164B SP Mukherjee Road. I find the premises number 164B SP Mukherjee Road does not form part of the suit property herein. And as such, no decree can be passed in respect of a non-suited premises. In my opinion, the plaintiff is thus not entitled to get a decree or mandatory injunction in respect of prior D of the plaint. Yes. Considering all the above, I find the plaintiff has been able to prove his case, but in part, court fee paid is correct, that the suit B and the same is decreed ex parte, but in part, plaintiff does get a decree of declaration that he is a monthly tenant in respect of the suit property and that he may not be evicted from the suit property without due process of law. This is in respect of 164A. And 164B, our lordship, I had shown my rentresses from 1967, which is still continuing. There was no disturbance in 164B. So therefore, 164B, I did not seek any declarations. I wanted a common declaration in respect of the common passage, which allows me to approach 164B from 164A. The learned trial court did not give me that, since it is not part of the suit property. But for today's purpose, both 164A and 164B are covered. Now, lordship kindly comes to page 287. This is the decree schedule. Lordship got it? Kindly says, all that piece and parcel of the tenancy of the plaintiff situated and lying on the ground floor of premises number 164A, Shama Prasad Mukherjee Road, PS Taliganj, Kolkata 26, District South Chobbish Pargana, along with the common user of common 3 feet wide passage, bath, privy and tap water connection on the ground floor at the end of the said premises, butted and bounded, one room with the asbestos shed, bracket workshop. This is my jewelry shop. On the ground floor at the premises number such and such, along with sanitary services, common bath and privy. So this is my contention. Next page, my lord, kindly says, the plaintiff does get a decree of declaration that he is a monthly tenant in respect of the suit property and that he may not be evicted from the suit property without due process of law. The defendants are restrained by way of permanent injunction from interfering with the peaceful possession of the plaintiff over the suit property. Suit is thus disposed of. So therefore, there is a subsisting order of civil court. My argument is the property got mortgaged. When mortgaged, I do not know. But when the property was being mortgaged, as a secured creditor, my learned friend's client ought to have and must have inspected the property and seen my occupation. Subsequently, when they issued, must have issued, I do not know, I have no knowledge, 13.2 notice, 13.4 notice, before proceeding section 14, they must have taken certain steps as prescribed under the RDT Act and the SARFAESI Act. If they have taken those steps, at that time also, they must have seen the property. They has not done it blindly, they ought to have seen it.
21 of reply stated report.
But when approaching the district magistrate, they did not disclose my possession. Lordship kindly says the Lordship had asked for
21 hour reply.
Lordship has asked for the reply for a report from the state. The state had already submitted a report, which is annexed to my affidavit in reply.
Page 21.
That's otherwise also will be available.
Page 21 of this reply to page 21.
Which page of your reply?
21.
At page 21, the state's reply starts.
Yeah.
20, statement of fact in connection with.
Yes.
This is what has been submitted by the state. Lordship, this is what the bank had submitted
before the district magistrate.
district magistrate. Lordship, kindly turns, they submit this kindly turns comes to page 23.
Yes.
Second last paragraph. The property is not under lessee and tenancy. This is what the district magistrate notes. That means their affidavit, which is not here, which my learned friend's client may be asked to produce, shows that there is no tenancy, which is suppression of the material fact, on the basis of which they obtained this order from the district magistrate. Therefore, if Lordship again comes back to the notice that does not reflect my name, district magistrate is unaware. In such a situation, whether the action of the bank in getting the notice issued against me can be sustained. This is my first limb of argument. Second limb of argument is, for which, in respect of which I thought that I'll be showing few decisions of the Honorable Supreme Court, that a tenant, bona fide tenant, whether a lessee or a premises tenant, cannot be ousted because of the mortgage if the said mortgage, said tenancy is for pre-mortgage period. Honorable Supreme Court made a clear distinction regarding pre-mortgage tenancy and post-mortgage tenancy. The pre-mortgage tenancies, when established, are protected. My third point is, I am a tenant, I am not a lessee. I am a tenant under West Bengal Premises Tenancy Act, originally 1956, then now under 1997. My tenancy does not stand determined. Is not determined as yet. And when the property is mortgaged, subsequently auction sold, and third party interest already created, which my learned friend's client has already stated in the affidavit. So that auction purchaser comes into the shoes of my landlord. That auction purchaser can take the necessary steps to oust me. Auction purchaser is not before Lordship. Bank has sold the property on as is, where is, as it is, where is basis.
As is where it's.
As is where is, as it where is.
Whatever there is basis.
Wherever there, whatever there is.
That is the line. If that be the case, then there is no reason for the bank to pursue their that I should be dispossessed and the property should be handed over. And Lordship kindly sees Lordship's orders. Lordship has given them the orders on the very first occasion, I think, in their favor, saying they can take possession of the rest of the property except mine. They must have taken by now. So there is no reason why I should be ousted. My learned friends will take a point regarding the maintainability of the writ, which I will satisfy Lordship that the writ is completely maintainable. My learned friend will take the point that I can approach the tribunal, learned tribunal under section 17(4)(a) of the Act. But 17(4)(a), I would argue that is not applicable in my case since my name itself is not there. I am not recognized.
May not be recognized, but the line starts, any person aggrieved by the order or
Any person
dissatisfied.
agreed, but what
Any person would include you.
what are the points of determination? Those points are already determined. Lordship kindly says, any person in an application under subsection 1 claims,
May I hand over a copy?
No, it's all right, you read. I can understand.
Lordship has claims any tenancy or leasehold right upon the secured asset, the debt recovery tribunal, after examining the facts of the case and evidence produced by the parties in relation to such claims for the purposes of enforcement of security interest, have the jurisdiction to examine whether the lease or tenancy, so it's not only lease, tenancy also, has expired or stood determined, which is not my case. B, contrary to 65A of the Transfer of Property Act, not contrary. Third, is contrary to terms of mortgage. It is a pre-mortgage, so it could not be contrary to the terms. D, is created after issuance of the notice of default and demand by the bank under 13(2). That also is not satisfied. So there, and moreover, when already a declaration, a decree of declaration stands in my favor, what more the learned tribunal will look into it? Can the learned tribunal sit over the decree of declaration passed by a competent civil court? I'm asking myself. Cannot.
No, but then why before 226 court and not before the tribunal? This
I am
is the...
in 226 court because my learned friend's client has not disclosed properly. Why when the action becomes mala fide? The action becomes mala fide when the authority acts in exercising its authority, exercises its authority, which is vested in it, without resorting to the proper procedure and disclosing all facts. The district magistrate could not have recorded that there is no lease or no tenancy unless their affidavit is so. In learned friend's client affidavit, they have not disclosed their affidavit before the district magistrate. That has not been disclosed.
In the affidavit which has been filed by the bank,
yes,
is there anything mentioned about the fact as to whether the mortgagor disclosed your presence over there?
No. Rather, claims that I should have known that the property is mortgaged.
And how you should have known is not.
Not because I have gone there. Bank says bank has gone there. Bank has pasted the notices. Bank has done this. Bank has done that. Then the bank must have known that I am there. Bank's own affidavit shows that I am there. Lordship kindly comes to their affidavit.
Yes.
Paragraph Roman 5. Page 5, Roman 5. While taking physical possession of the secured assets for the first time, the respondent number 3 and 4 came to learn that there is a tenant occupying more or less 60 square feet and 40 square feet in rear side of the premises of the secured asset situated at such and such. Now, Lordship kindly sees paragraph Roman 1, how it proceeded. Roman 1 at page, it should be, page number is not there, page 3. So the page number এখানে আসেনি। The borrower of the respondent number 3 and 4, namely Precision Engineering and Fabricators Private Limited, prior to its liquidation, availed credit facility from the respondent number 3 and 4 on various terms and conditions contained in the sanction letter issued by the respondent number 3 and 4 in favor of the said borrower measures Precision Engineering. This is their side of the story. Due to the irregular maintenance, the account of the borrower classified and declared NPA with effect from 30th March 2015. Lordship kindly notes, 30th March 2015 is after my decree of declaration.
Your decree is in 2016.
2016, my suit is of
Suit is-
2013. And in the Roman 1, they did not disclose when they gave this loan. That is not disclosed. As a result thereof, respondent number 3 and 4 on 7/6/2023 issued 13-2 notice. What took them 8 long years? NPA of 30th March 2015 and 13-2 on 7th June 2023. My learned senior friend knows why, but it may not come on the affidavit.
What is the reason, according to you?
Sir?
Not very profitable.
Huh?
Not very profitable.
The borrower.
Yes.
The persons who are holding, who are behind this mortgage.
Yes. Who are they? Political leaders. That is the reason you are not in a position, neither of the parties is a position to say.
Maybe.
Why? Maybe you are before a court.
I do not know. I cannot say it on oath or affidavit.
All right.
Issued notice under section 13(2) of the SARFAESI Act as amended and subsequent thereto issued notice under 13(4) as amended and took symbolic possession of the secured asset. All that piece and parcel of Bastu land such and such.
13(2) is date is mentioned.
But 13(4)
date is not mentioned.
Lashik kindly turns. Roman 3. Since the borrower and its guarantor failed or neglected to pay the dues either in full or in part as mentioned in section 13(2), the respondent number 3 and 4 put the secured asset for sale by issuing notice under 8, 6 and 9 of the Security Enforcement Rules 2002. Ultimately, the sale was scheduled on 15 December 23 and respondent number 3 and 4 while conducting the e-auction received the highest bid from this person. After sale was confirmed for handing over the secured asset, the respondent number 3 and 4 filed an application under section 14 before the DM South Chobbish Pargona in compliance with all the formalities, and an order was passed by the DM South Chobbish Pargona regarding physical possession of the secured asset. This was also not known to me. While taking physical possession of the secured asset for the first time, the respondent number 3 and 4 came to learn that there is a tenant occupying more or less 60 square feet and 40 square feet in rear side of the said premises. Secured asset situated and lying at such and such. Being agreed by and dissatisfied with the said action of the respondent number 3 and 4, the petitioner filed the instant writ petition. Because a note came, notice pasted, and I was asked to vacate. That prompted me to immediately come before Lordship. Now kindly says, page 6, paragraph 7. I say that I have got no knowledge with regard to any occupation and or tenancy in respect of property situated at such and such. This is what the bank says, that they had no knowledge, which in my humble submission is not possible because bank must have done due diligence.
Or if they have not done, they'll suffer the consequences.
I should not suffer.
The bank.
For their lack of due diligence. save and except what are matters of record and what would appear therefrom with regard to the statements and or allegations contained in my writ petitions. I repeat and reiterate the statements contained in all subparagraphs of paragraph 3 hereof, and deny all allegations contrary thereto and inconsistent. I do not have any knowledge regarding filing of the purported suit and obtaining an ex parte decree against erstwhile landlord, who, while transferring the secured asset to the borrower, did not mention regarding occupation of any tenancy. In respect of the secured asset, and as such, the decree for declaration of tenancy passed ex parte in civil suit and is not binding upon the purchaser. My lord, this is not the law. If I suffer a decree, that decree flows in perpetuity to my whoever comes into it through me. Decree is binding. I say that in the instant case, it is admitted that after filing of the instant suit, the secured asset, that is the subject property, is duly transferred by the erstwhile owner to and in favor of the defaulter borrower and or guarantor who paid the money in good faith without knowledge of the existing tenancy, and as such the specific performance of contract cannot be enforced against a subsequent purchaser. I do not know where from the specific performance is coming. And thereby the decree of declaration of tenancy in respect of the secured asset was and or is not binding upon the subsequent purchaser stroke borrower of the bank, and it is well settled principle of law held by Honorable Apex Court that if a decree be passed in a suit of specific performance of an agreement, cannot be binding upon the subsequent purchaser, and as such the suit of decree passed by the learned civil judge on 22nd June 2016 has got no adverse implication against the subsequent purchaser or borrower. This is an absolute question of law. I'll satisfy lordship that decision is also I was carrying. The defaulting borrower being subsequent purchaser of the said premises falls under the purview of section 19B of the Act, who is a bona fide purchaser being the borrower of the respondent number 3 and 4. I say that the order of district magistrate dated 31st July 2024 passed in an application under section 14 of the Surface Act as amended has got the power to vacate the alleged occupation of the petitioner, since the respondent number 3 and 4 was not party to the alleged suit filed by the petitioner and against ex-landlord whose right, title, interest over the properties were duly transferred by execution of instrument in accordance with law. What my learned friend's client is trying to say, that since a borrower has come and the borrower is not party to the decree, therefore the decree is not binding, and the mortgage being valid mortgage, the bank can proceed without following the due process of law.
The defendant numbers 2 and 3, are they anywhere mentioned in the whole document which they filed?
Envision.
Only envision.
Yes.
In name the party
Names
is not there. Gursharan and someone that it's not there.
Not mentioned.
All right.
Since the petitioner do not have any valid agreement of such alleged tenancy in pursuance of the settled principle of law by the Honorable Apex Court, the petitioner is not entitled to remain in his alleged occupied portion of the premises as alleged, and thereby the question of protection of law under Article 226 does not and cannot arise. Further, since terms of Section 17(4) of the Surface Act as amended, the petitioner being the alleged tenant have a right to move before the Debts Recovery Tribunal as and by way of efficacious remedy, and thereby the writ application is not maintainable as settled in such and such. This I will distinguish. Before taking possession of its secured assets, the respondent number 3-4 published notice in the daily newspaper, pasted of the conspicuous place of the secured asset, and as such, it cannot be said that no notice was given in respect of handing over the possession of the secured asset to the confirming purchaser. How the notice upon a confirming purchaser, even if given without admitting for a moment, because I am saying I had no knowledge, is binding upon me. It is well settled principle of law that if there is no stay and a secured asset is sold by the bank to the purchaser, The bank is bound to issue sale certificate and hand over possession of such secured asset. They're not prevented. They're not at all prevented from issuing the sale certificate. They can issue the sale certificate. They can hand over the possession. Only thing, I should not be ousted physically from there. At the very outset, I said, my lord, that the auction purchaser will step into the shoes of my landlord. After that, that auction purchaser will exercise his rights as a owner, and I will exercise my right as a tenant. I am a tenant under 1997 Act. It's a commercial tenancy. Since the respondent number 3 and 4 was not a party to the alleged suit, the respondent bank was not bound by the decree passed therein. This cannot be the position. Subsequent thereto, the original owner of the aforesaid building by registered instrument duly sold, transferred, conveyed the entire building, and subsequent thereto mortgage the same to secured loan avail from respondent number 3 and 4. This original owner is Esha Bhattacharya, though their name is not mentioned, but if they had disclosed the document, it must be Esha Bhattacharya. I do not know. Should be. It is well settled principle of law that a decree for declaration of tenancy in respect of property passed in favor of a tenant and against the landlord does not or cannot bind a subsequent purchaser, or to whom the landlord has sold, transferred, or conveyed the said property, unless particularly where the alleged tenancy rights are merely recited and recorded in the deed of conveyance and do not automatically and independently create or transfer any enforceable tenancy right. If my learned friend, being my landlord, sells it to my learned friend without disclosing my tenancy in his property, the tenancy right goes if this submission is given credence to. They do not disclose among themselves, and I am ousted. Save and accept what are the matters of record and what would appear
Thereafter, these must be all denials and
Yes,
everything.
yes.
Whatever he's got to say, he's said in these paragraphs.
Yes. These are his submissions, my lord, which in my humble submission cannot be sustained. As I am saying, there is no bar upon my learned friend in issuance of the sale certificate. Must have issued. Must have issued. I think I have seen that it has been issued. বিক্রি হয়ে গেছে, সেল সার্টিফিকেট ইস্যু হয়ে গেছে,
maybe may not বিক্রি হয়ে গেছে।
and possession must be given without physically ousting me. Rest of the properties, there is no bar, at least not here before lordship.
And you are also not concerned.
I am not also concerned. I only to the extent of my jewelry shop and jewelry workshop.
60 and 40,
60
100
and
square
40,
foot.
what they are saying.
100 square feet.
60 and 40.
more or less.
Decree is only in respect of the one property, not the another.
Yes, yes.
And in respect of the other property, my rent receipts are there from 1967 till date. First issued by the landlord and thereafter in the rent control.
Both the properties are contiguous to each other and one can be accessed from
By
the other.
That 3 feet common white passage.
CSC bill আছে, KMC
And yes, I have also annexed the KMC, my trade licenses, as well as CSC bills, as far as I could procure. So therefore, this is my humble submission, my lord, as regards maintainability and other
Why
things.
don't you allege fraud?
My lord, if I allege fraud, I may not be able to come to before lordship.
Why not?
Because then I have to file a criminal complaint.
No. You do a little bit more research.
I will.
Right? Because the bank is not supposed to know as to whether there is a tenant in a property which is being mortgaged. So it is the borrower who is supposed to disclose proper facts. Now, if the bank acts upon any suppression of fact, right? So that will be fraud played upon the bank by the borrower to obtain the loan.
Yes. From that angle, but because of that act of the borrower, purported act of the borrower.
Do little bit more research and see if you can get anything, because there is no direct judgment on this line as on date.
I will try to find out. I'll try to find out if a fraud has been on a public sector bank, if it has been committed.
And fraud vitiates everything.
Yes, it goes to the root.
So, whether you can be victimized for a fraud being played upon the bank by somebody else. And at the same time, you bring all the judgments, relying on which the writ court can at least enter into, because the Supreme Court judgments are very specific that Section 17 is a bar.
No, dear lordships, initial two orders might not disclose those judgments, because I referred this and your lordships mentioned those two judgments. And my lord, the latest judgment also, my lord, Section 107 of the Transfer of Property Act, if any property in a agreement for sale, if it is more than 1 year, it has to be registered, and if it is not registered, my lord, the Supreme Court says that you have to go. Well, that is the latest judgments of the Supreme Court. Well, there are
You
three.
also think it over. You are the bank,
Yes,
right?
Yes, yes.
Somebody plays fraud upon you. I would like to see the chain deeds from you, and I'll pass order, you bring those. Whether Asia was ever there before you, disclosed before you or not. Somebody who is a tenant since 1960, the landlord is not in a position to vacate the tenant, and relying on the SARFAESI Act provisions, he obtains loan and gets his tenant vacated. How much this can be allowed?
I can, my lord, only thing I can say, my lord, my instruction is that the purchaser was also a tenant. And it's a collusion and conspiracy in between the two tenants. My lord, I can say, because it is my...
Purchaser was a tenant of a portion.
No, of the same building. My lord, no. Who has purchased the entire building? No, entire building. Who has purchased?
He was tenant of a portion of that building and he purchased the whole building.
Yes.
That means the erstwhile tenant of a portion is trying to evict this tenant by obtaining loan from the bank.
Maybe, my lord, your lordship.
What
Maybe.
may-
No, right, your lordship's assumption is correct. Yes, my lord, I understand.
You are a public sector
Right, my lord, yeah, I
bank.
understand.
You are not a private party.
Right.
And I can tell you that your officers are also involved with this. They are aware that a tenant is there.
My lord, your
And since a tenant, a very small one, 40 square feet, will not be able to run up to the Supreme Court. And this is the reason this is the manner as to how I get rid of him. This is the way of evicting tenants, right?
My lord, your lordship mentioned one thing, whether there is any political pressure or not.
Yes, sir.
Lord,
I didn't mention.
No, your lordship, yes, he just come out.
It
Yes.
came out.
Yes.
And you succumb to that.
Yes, my lord, I personally feel that yes, there was some renowned person.
Yes.
India, my lord,
Involved in the whole thing.
not his relative is involved.
Whoever.
Yes. My lord.
Name was it?
Some amount of pressure was there.
Maybe with the erstwhile landlord or so.
Whoever.
Yeah.
The court is not concerned.
Yes. Not,
The court is here to see
right.
that
Justice
somebody,
has been done or not, my lord.
yes, somebody is not evicted without the due process of law. This is the core thing.
My lord, I beseech to your lordship, my lord, I also personally feel, but the Supreme Court, my lord, once after another, my lord, order is being passed, that if any agreement for tenancy...
But you are the bank, you can go up to the Supreme Court. How can this poor tenant go?
No, my lord, the orders are being passed in several matters. Several judgments has been passed by this Honorable Supreme Court that if the tenancy is more than 1 year, it has required to be registered under Section 107.
Let this judgment also go. Let the Supreme Court deal with it.
Lord, we
At
are in
least
difficulty, my lord, every
till
day, my lord.
such time the tenant gets a breather.
My lord, maybe. My lord, every day, my lord, the judgments are being changed. Every day,
Yes.
that is we are difficulty.
You
my lord.
also face the
Yes,
problem.
yes,
The
my lord.
court also face the
Yes, my
problem.
lord, I
It is
feel,
not
my
that
lord.
you only face
Yes,
problems.
yes. My lord, today, if I produce a judgment of the Supreme Court, your lordships may differ that now this is a current judgment. This is so that's that decision, my lord, we are suffering, my lord. We are suffering. We are not ensured that what judgment is correct and what is the correct position.
Whatever.
Madam.
Please come.
Yes.
Ashok, there was an interim order till
Interim order till
Friday, next Friday.
15th of May.
kindly be extended.
All right.
My lord, kindly keeps it
Done it.
uttered, my lord.
It is an assigned matter.
Yes,
sir.
yes, yes, very good, my lord. Very good, my lord.
That is the reason I heard. Otherwise, I would not have heard because the state is not here today.
Yes, yes.
Yes.
But state will not be affected party, my lord.
I understand.
Whatever judgment will be, my lord, the state will not be affected person.
State has done its work.
Right.
Notice issued.
Yes.
It's over.
Very good. Thank you.
Learned advocate representing the petitioner commences argument but does not conclude the same. Stop. List for further argument on 12th June.
12 June.
The interim order that is subsisting in the matter is extended till 28th of August 2026 or until further order, whichever is earlier. Learned advocate representing the bank is directed to produce the deed of mortgage along with the chain deeds of the subject properties. Properties, only two properties.
164A and 164B.
164A and 164B of SP Mukherjee Road.
Yes. But the original deeds I cannot produce because it has already been handed over to the purchaser. So I can produce or Xerox copy. Xerox copy. Yes, my lord.
Yes, yes.
Photocopy. Yes.
No issues.
Because another suit is also pending before the civil court in Alipur court.
Between whom?
Between, my lord, Envisage Builders.
With?
Envisage Builder.
Between Envisage and?
And where, my lord, Union Bank of India was also a party.
Between you and
Envisage Builder and their and Precision Engineering.
petitioners are not there.
No, directors of the Precision
It
Engineering.
doesn't matter. Petitioner is not concerned.
No.
So the court is also not concerned. You may have so many suits against so many persons. Achha.
No, they have filed a suit, my lord, against the
Doesn't
yes.
matter. How does this matter?
No, my lord, I just I have come to learn because in that matter also, my lord, we are also appearing. Bank is also appearing contesting the suit.
Where?
Alipur court.
But whether the schedule of the suit that you are mentioning include the portion of the petitioner?
Yes, yes, because entire property.
Entire property.
Yes, 2 kathas something and 1 katha something.
All right.
So that is entire.
Are you aware of the suit?
No.
Check up. Check up.
Because
Because in case your portion is also there,
forward, I need to intervene.
you need to intervene and you need to make your stand clear over there. কি বললাম? Subject properties where the petitioner claims tenancy. On the adjourned date. Yes.
I'm deeply obliged.